Every US visa story begins with one of three ingredients: love, talent, or money. Today, we're talking about money. If you've been thinking about obtaining a US green card through the EB-5 investor program, there is one date you absolutely need to know, and that is September 30, 2026. No, that's not the day the EB-5 program expires. And no, it's not the deadline to receive your green card. But it may be the last opportunity for many investors to file under one of the strongest legal protections Congress created in recent years. I'm Tapias, CEO and immigration attorney at Loigica. And today, I'll explain why September 30 matters, what grandfathering really means, and whether waiting could ultimately cost you much more than simply delaying your case. What is grandfathering? When Congress passed the EB-5 Reform and Integrity Act, it introduced an important protection known as the grandfathering provision. In simple terms, investors who properly file the EB-5 petition before September 30, 2026 receive statutory protection under the current regional center framework. That means if the regional center program later changes, expires, or Congress modifies the law, qualifying investors who filed before the deadline generally remain protected under today's rules for purposes of continuing adjudication. That is extraordinary level of certainty in the field of law where the rules often change. What about the investment amount? Today, the minimum EB-5 investment remains $800,000 for qualifying target employment area or TEA and qualifying infrastructure projects, $1,050,000 for most other projects. I often get asked, should I wait until next year? The honest answer is no one knows. Congress could leave the investment amounts exactly where they are. It could increase them. It could modify other eligibility requirements. The truth is that no attorney can promise what Congress will do, but history teaches us one important lesson. Immigration investment thresholds rarely move downward. Why filing before September 30 matters. Many people think this deadline is only about investment amount. I actually think the bigger benefit is certainty. If you properly file before September 30, 2026, you gain protections of today's statutory grandfathering provisions. After that date, new investors may no longer have the same level of protection if Congress changes the regional center program. In other words, you are not locking in today's investment threshold. You're locking in today's legal framework. And for families making an investment of hundreds of thousands of dollars, legal certainty has enormous value. Should investors rush? Now, let me be clear. I'm not suggesting anyone rush into an EB-5 investment. You still need to perform proper due diligence. You need to evaluate the regional center. You need to understand the project. You need to verify your source of funds. And you need to determine whether EB-5 is even the right immigration strategy for your family. But if you've already decided that EB-5 is the right path, I will not wait until the last minute. Preparing an EB-5 petition takes time. And the closer we get to the September 30 deadline, the more filing volume we can expect. The biggest takeaway is this: September 30, 2026 is not simply another immigration deadline. It's an opportunity to file under today's legal framework and obtain a benefit of Congress's grandfathering protections. Could the investment amount remain exactly the same after the date? Absolutely. Could Congress increase them or change other program requirements? That's also possible. The point is this: no one can predict the future, but investors can control when they file. If you're considering an EB-5 investment, now is a time to evaluate your options, not after the deadline has passed. And remember, every US visa story begins with one of three ingredients: love, talent, or money. I'm Tapias. I'll see you in the next video.